કેવલની સહ આરોપીઓ ધવલ, સાવંત, બ્રિજરાજ અને અન્ય સાથે ચેટ ઉપરથી તેમજ આરકે આંગડિયા પેઢી દ્વારા આપેલી માહિતીના આધારે મળી આવેલ છે, જેની માહિતી તે ગુનાના તપાસ કરનાર અધિકારી પાસેથી મેળવતા જાણવા મળે છે. તેમજ આરોપીના કેવલના સીડીઆરની માહિતીમાં પણ તે સહ આરોપીઓના સતત સંપર્કમાં હોવાની તેમજ તેઓ જે સેફ્રોન ટાવર વાળી ઓફિસે બેસી ગુનાહિત પ્રવૃત્તિ કરતા હતા ત્યાંના તેના લોકેશન આવતા હોવાના પુરાવો મળી આવેલ છે. સો other than this confession statement under section 16 of this act has been recorded, wherein he conceded that he has a relationship with Savan Dhaval and he acts on behalf of Savan and Dhaval. So yes, it is safe. But it was on technical ground, not on merits. So long as it is stayed, I can make, otherwise I can make a submission like this, that since the magistrate has allowed the application, but the trial and the proceedings before this honorable court is still intact. I'm not aware that whether they have also prayed for the stay of the trial or not, because the application was stayed, that particular order has been stayed, but after that order, much water has been flowed. The charge sheet has been filed before this honorable court. The honorable court has taken cognizance. Thereafter, the competent authority, that is State of Gujarat, has also sanctioned, approved the sanction so far as the taking cognizance before this honorable court. So all that proceedings have still remained intact. My respectful submission, the proceedings are key. There is no challenge with respect to proceedings which is pending before this honorable court. Only on a technical ground, the order has been stayed. That is also the order of the magistrate has been stayed. Honorable court may kindly appreciate, for sake of argument, if the Tutsi talk sections are stayed, that because the particular the application which has been filed by the investigating officer has stayed. But what about the remaining offences that is under the IPC offences which are still intact? Now, if the honorable court shows the merits of the matter, there are sufficient grounds that he is on a equal footing with the main accused, because he is the person who is handling the cash transactions of the syndicate. He is the person who is going to Angadia Pedi and deposit the amount which has been collected by illegal means. And there are statements of Angadia Pedi persons that he knows these persons. He comes to the Angadia Pedi for deposit of amount. There is a statement of Gaurang Parekh, who is the person in whose bank account the transaction, illegal fund has been deposited. For time being, I may not praise that statement, but there are other aspects also which I humbly request the Honorable Court to taken into consideration. His role, so far as this case is concerned, the incident is concerned, 3 offences are there, but the modus operandi remains same. If the Honorable Court would not appreciate this aspect, if he enlarge on bill, he will again commit such type of offense.
charge sheet. Sir, if your lordship may have on page number that particular time he was working, he was doing job at this office. And whatever, if they allege for the sake of argument, it may be considered then it was just done on the instruction of this Dhawal Sakra and Savantar because he was doing job.
Please. સર એક દિવસ પાછા રાખીએ 26 તારીખ જો આપને અનુકૂળ 26 પ્લીઝ.
Account said whichever the proprietor himself is coming before this honorable to decrease the account. ડિસ્પ્યુટેડ જે અમારું કોટક મહિન્દ્રા ટ્રાવેલ પ્લાનર બેંક અકાઉન્ટ જે છે એમનું એમાંથી સાહેબ 2,00,000 અને 6,00,000 ડિપોઝિટ થયા છે એમના ખાતામાં 8,43,000 અબાઉટની અમાઉન્ટ છે.
સાહેબ 6,00,000 જેટલા જે અમાઉન્ટ રકમ રહી અમારી રીતે તો 45,000 અમારું એકાઉન્ટ ફ્રીઝ કરવામાં આવ્યું છે. આમાં કંઈ ગેમ રમ્યા નથી ઊંચા એકાઉન્ટ એ અમારા જ છે પૈસા. એ સાહેબ સાઈડમાં રાખો પેલા આગળ વોટ્સએપ છે તે આવે છે. ના ના સાહેબ એ આપણા હાથે રહેશે આપણા આવે જ છે. ના આ વખતે બધું સાચું જ છે. આ વખતે આરંદારે સાચું છે બધું સાચું જ છે.
સાહેબ જે ડિસ્પ્યુટેડ કંપની છે મહેન્દ્ર હોલિક ઇવેન્ટ એન્ડ ટ્રાવેલ્સ પ્લાનર બેંક અકાઉન્ટ છે એમના ખાતામાં સાહેબ આઈસીઆઈસી બેંકમાં ખાતામાં જમા થયા છે એમના ખાતામાંથી જ સાહેબ આમાં જમા થયા છે 2 lakhs rupees અને 6 lakhs rupees ડિફરન્ટ ટુ ડેટ્સ સાહેબ એ ખાતું છે બેંક એમના ખાતામાં જમા થયા છે જે મહેન્દ્રા બેંકનું ફોનિક ઇવેન્ટ ટ્રાવેલ્સ પ્લાનરનું જે ડિસ્પ્યુટેડ અકાઉન્ટ છે એ અકાઉન્ટમાંથી જમા ધેટ ઇઝ વોટ અવર વર્ક બે ડેટમાં થયા છે સાહેબ 11/8/22 અને 12/8 2605
કરીએ કરતા બી ખાતું ઓપરેટ થઈ જાય પૈસા ભલે જમા રહે વાંધો ના હોય ખાતા પૂરતું સાહેબ અરજી મંજૂર કરો પૂછી લો
સોમવાર 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 સોમવારે हाईकोर्ट में से आई की सॉरी आयु सोमवार
सर आता मुझे तुम्हारा बात करता आप इधर तो
पच्चीस पच्चीस जी yes sir temporary bail application on the ground of illness of father.
petitioner, this petitioner who used to work as a real estate broker, now he has been implicated in a case of Gutsito just because his brother, the accused number 1, against whom, my lord, the allegations of Gutsito were invoked. He was cited as a person who was gang leader, and my lord, because of my blood lineage similar with him, I and my another brother were taken as accused, co-accused in case, and we were shown as members of this organized crime syndicate. But in fact, my lord, no evidence in toto would suggest in the entire charge sheet, my lord, to show me as a person who has actively participated as a member of this organized crime syndicate. I would request my lords to kindly see the FIR, which starts from page 16. And on page 17, my lord, I am shown as accused number 3. I am Ajmal Bhai Rabari. And my lord, the persons, each and every accused person's, my lord, details are shown in the FIR itself. Against me, my lord, there are 3 FIRs have been stated, which were considered by the investigator, the complainant, the agency, for showing me as a part of the syndicate. Against, sir, these 3 FIRs, if I take my lords to the very first FIR, which is on page 55, sir. On page 50. On page 50, the very first FIR has been shown that FIR was lodged under section 294B 506 subsection 2, coupled with 427 and 114 of the IPC. And on page 51 in column 7, I was not named. My elder brother, Bharat, against whom there were allegations, and one Hari. But no name of the present applicant. There is no role, no allegation, no overtake by the lord present applicant, which has been alleged by the complainant. Here, my lord, in this case, I have granted bail by the honorable court, and here, my lord, charge sheet has been filed, and that case is pending. It's not the case where, my lord, the case has been decided and I was held guilty by the honorable court having jurisdiction. Then, my lord, the very second FIR, page 54. Page 54 FIR, my lord, BNS section 351 subsection 4 with 352 and 54 of the BNS. Here, my lord, I am named as accused number 3 in column 7. હવે સાહેબ પેજ 56 છે ને એમાં બહુ શોર્ટ ડિસ્ક્રિપ્શન છે આ FIR નું ફરિયાદી દ્વારા. એ with kind permission of my lord, I am ready if your lordship will permit. Only 2-3 lines આના ડિસ્ક્રિપ્શન ની. Page 56%. I will show only my role. Last but the 4 line, આ બંને જણા is a reference for the Bharat and another accused number 2. ત્યાંથી સાહેબ વાંચું છું. આ બંને જણા તેના ભાઈ અજમલ ભાઈ સુખાભાઈ રબારી નાઓના કહેવાથી મને ગાંધીનગર ખાતે ધંધો નહીં કરવા તેમજ કોઈ જમીનનો સોદો નહીં કરવા બાબતે ખોટી રીતે હેરાન પરેશાન કરવા ફોન કરી ગાળાગાળી બોલી મારા પરિવારને મારી નાખવાની ધમકી આપતા હોય અને આ અજમલભાઈ સુખાભાઈ રબારી પણ અગાઉ મને ગાંધીનગર ખાતે જમીન દલાલી નહીં કરવા બાબતે ધમકીઓ અગાઉ ધમકીઓ આપેલો, but there is no FIR, there is no complaint, formal complaint, 100, nothing against it. Just because this complainant has given FIR against the co-accused person, my lord, he has only given one line, he has stated only one line કે મારા કહેવાથી કર્યું હશે, but there is no concrete proof. Here also I have granted regular bail, charge sheet has been filed, and then trial is pending. Now the only last FIR, page 58, sir, the third FIR and the last FIR, section 385, 511, 4472, 427, coupled with offences of rioting. This has been lodged wherein I was not named, sir. And here, my lord, subsequent to the lodgement of the FIR, a compromise has taken place between the parties. We have approached before the Honorable High Court. We have preferred consent quashing petition. That quashing petition was allowed. Page 62 is the order. It was quashed and set aside. Despite this, my lord, the FIR has been considered while lodging the FIR under good seat, while taking me as an accused, as a member. Now, my lord, the investigating agency is alleging certain transactions which, my lord, had taken place into my bank accounts, for which, my lord, for a period of preceding 10 years, for which, my lord, I have a plausible explanation. I have been involved in business of, my lord, purchasing, selling the real estate plots, lands, and properties, and for which, my lord, this transaction have been taken place. There is no iota of evidence which could suggest, at least point a direction, that this amount which has been either received or has been transferred from my bank accounts would be a part of any amount which has been, my lord, obtained by this syndicate by committing any unlawful activity. It is absent, sir. There is only one aspect, and that aspect is that I am a brother of the main accused and the co-accused. Just because of that, my lord, I have taken as an accused in this FIR. And I surrendered, sir. I surrendered. The moment I received call from the investigating officer concerned, I, my lord, approached the investigating officer and I surrendered. This is not the case where, my lord, I ran away or, my lord, I have evaded my arrest. This is not there. Before investigation, during the course of investigation, before stage of charge sheet, I preferred the bail application before my lords, and your lordships were pleased to reject the application. I approached the Honorable High Court, and my lord, that application was also withdrawn. I place into service the orders for your lordship's kind perusal. Now, sir, investigation is over, charge sheet has been filed, and I shall not flee away from the cause of justice, and I shall mark my presence on each and every day of the adjournment made before this honorable court during the course of trial. I am a man with, my lord, responsibility for my family, and I am a resident of Gandhinagar. And there are no offences of firearm because, sir, જે ફરિયાદમાં જે ક્રક્સ છે ને ફરિયાદીનું કે આ ગુનાહિત પ્રવૃત્તિ કરનારી ટોળકી એ એક્સટોર્શન ફાયરઆર્મનો ઉપયોગ કરીને કરે છે. So there is no allegation of using or possessing any firearm. So considering all this, my lord, I would request my lords to consider my bail application with any stringent condition. Please, sir.
Please. It is not there in your application. No, that is
Supreme.
so that was before thereafter it is taken down. Now, it is a comprising of 6 accused person, and this accused person has committed or 9 previous offenses. Now, out of this active 41, 4 active persons are absent and against them the target is determined. 2 active persons are still absent. Now, the indicate, this particular indicate has target instead of 2020 and then activity will continue in 2026. And the operation that we indicate is within the channel operating. It is partner and the one taking and together. So those 9 offenses are filed in different districts. And the modus operandi for the offenses for which we indicate in communication, we give them નામ that બનાવટી દસ્તાવેજો etc. So the object of the indicating to operate a supremacy in the area whereby the victim or the complainant, those 9 complainants who have filed the FIR, and that person is succumb to their now so far as the present applicant is concerned, the applicant is active number 3. The applicant happens to be the main, the brother of the main actor. Against the present applicant, he offenses are registered. As my direct hand has pointed out, case number 50 is the honorable court of FIR respecting register in the year of 2022 at Masterapur police station. My direct hand has taken the honorable court of that particular FIR. That is like to point out what are the list of allegations in that FIR. And it's a page number 51 for my register. Column number 12. ગાડીના બોનેટ ઉપર તાળા પાડી નુકસાન કરી જતા રહેલ હોય એ વગેરે પ્રકારની ફરિયાદના રૂબરૂમાં લખાઈ હતી. So this is one of major aspect is present conflict has been filed. Page number 54, the Honorable Court of Appeal is effectively second FIR. It has been fought by the Honorable High Court. Such kind of persons are better and saying that you stop the business of my business. This is how the FIR has been stopped. Now, page number 58 is the FIR
transaction is made by the first. That allegation is that. In fact, because I have given this amount in my IT. And another. Another because this 52 FIR was my suggestion. FIR. ना सर भाई एक मारा एक पॉइंट अगर 0.5 इतना जमो कि ये एफआईआर पर ये सर करे बैन ना आ रहा है ये एफआईआर बंद ये 52 वाले ये भी मारा नाम है हां भाई अब ये तो सर ये एफआईआर की साइड में निकाल के देगा पता है ये मारा नाम है એમાં પેજ 52 પર છેલ્લી લાઈનમાં ફરિયાદી પોતે લખે છે કે આ ભરત અને હરીએ મારી ગાડી છોડી એવી મને આઈ એમ નોટ ભરત નોર આઈ એમ I'm not Bharat, I'm neither Bharat nor Bharat. Allegations were against Bharat and Hari in that very FIR. Page 53. I am brother of Bharat.
Accused number A5, accused number 5. I'm the principal accused. So the allegation against me is that page number 52 of the complaint. Para number 8.5. May I read? Shri Sunil Surendra Kumar Kakkad, promoter, managing director, director of SIS, AIPL, DTPL and Sujit Infrastructure Limited was mastermind in the fraudulent activities regarding obtaining of loans from consortium of public sector banks during 2019-13. He was controlling day-to-day affairs of the accused company and its group company. Shri Sunil Kakkad through its company SIS, AIPL, CTPL availed credit facilities to the tune of 867 crores on pretext of various project-based term loans, letter of credits, and also cash credit limit with the help of forged and fake documents, stock statement receivables without any genuine trade transactions to utilize the funds through receipt for the unauthorized purpose by diverting the same for other use, including acquisition of various immovable property versus sources. So, the first allegation against me is that I submitted forged and fabricated documents for availing the loan. Along with the complaint, not a single document is placed on record. Once you allege that I placed fabricated stock statements, so you place those stock statements on record. Not a single document is placed on record with the complaint. In fact, they filed a report in the complaint. That report is absolutely immaculate. I have connected with my discharge application as well, but in the complaint, it is at page number 280. The list of documents, page number 280. This is a report given by the complaint bank. So that's page 280. It is a report of the bank. What the complainant SBI. SBI. It is an internal investigation report. The page number 286. 286 marks have major projects backed by the company in present status. Call center, voice and video over broadband, internet data center, National Mission on Education with Information and Communication Technology. So all these are projects which were given to us. And on the basis of these projects, loans were sanctioned to us. And the ultimate conclusion of the report is at page number 297. 299, sir. page 299 of the report is the conclusion. The reasons for the failure of advance may be summarized as under why we were not able to repay the loan. Not a single allegation of fraud forgery. The only thing they say is the company under the leadership of Sunil Kakkar was poised for rapid growth in a very short time span. The company was awarded prestigious projects from BSNL, DOP and Home Department, Government of Maharashtra. The company was competing with other global players like TCS, HP, Infosys, Wipro, HCL, IBM, etc. In the bidding process, the company did not have infrastructure which may be considered as part of other global players. The affairs of the company were solely managed by Sunil Kakkar and it immediately collapsed with the appearance of 3%. The company used to participate in higher value projects without proper TAV study by a reputed from the company did not ensure proper financial closing before furnishing AMD, PBD, post-dated check. The terms of financing fixed assets were not properly understood at the time of appraisal by the bank since the terms of the projects were not fulfilled by SIS. The equipment stands transferred to BSNL at zero cost. Realization of receivables is also linked to provided uninterrupted AF services, failing this the entire receivables amounting to 506 crores has become doubtful of recovery. So, Milord, the allegation is that I have given false and fabricated documents. Now, Milord, those prove that I have given false and fabricated documents, they are required to produce those documents. Those documents are not on record. The report which is filed on record says otherwise. The report does not say that there was any fraudulent transaction by us or any forgery done by us. The report only says the business failed because we did not have the infrastructure as compared with global players. And in para number 5, it specifically notes that there are 506 crores receivables from BSNL and other companies which have become zero. So, Milord, there is a question of submitting false statements where they themselves recognize that there are receivables up to 506 crores, but their recovery is doubtful and therefore they have become zero. And those receivables are from reputed companies like BSNL and Government of Maharashtra and other companies. The second allegation is that funds were diverted by the company for purchasing properties which are mortgaged to the bank. The allegation is not that Sunil Kakkar diverted the amount. The allegation is company has used those amounts for purchasing property. Now the company, a loan was sanctioned to the company for business purpose purchased properties, and same properties are mortgaged to the bank. So how come there is no concealment of property, there is no hearing for establishing the offense of money laundering? And you know the final allegation, there is one more allegation against us that 20 lakh rupees was transferred to one Bagish that is given in para number 8.5. Now say that 20 lakh was transferred from my personal account. It was not transferred from the account of the company. The allegation, there is not a single allegation that the loan was sanctioned to the company and the amount and the loan was diverted into my personal account. That 20 lakh was my earnings, which I have given to the person. At the allegation means that the amount had gone from the account of the company to Bhagesh, I understand it was a case of diversion. Ultimate submission is for establishing the offense of procedure of crime. They have to establish there is procedure of crime. For establishing the procedure of crime, there is false and fabricated offense. Both documents are not on record. There is nothing with the company.
In addition to this, there are also funds of 12.5 crores that are also diverted by site to Sojitra, which is owned and present applicant was again charged and managed the bill of the. It's also for the SIS for profit carry on the law. In addition, the period is 29 level to 18 of people. I the system has transferred the funds of 43 crores from the fund it was transferred to micropower sector limited, and from that micropower sector it was transferred again to Canyon Protect during the same period. Timing period for the transaction would be within the span of 1 month, and that fund was again transferred to the Joe for the same immovable properties again, diverting the funds of right to accordingly. The price was identified and attached by the distribution policy and found by the administrative authority. In addition, 20 lakhs was also diverted by the for the sale of land at 101 is the right. This is again it was one of the according